Listen carefully. If you hold a green card or you're about to become a permanent resident, major changes are rolling out right now that could affect your business loans, your ability to travel freely, and even your green card status itself. Some of these restrictions start as early as March 1st, and if you're not prepared, you could face serious financial losses, travel delays, or worse. Stay with me, because what I'm about to share could save you from making costly mistakes that might jeopardize everything you've worked years to build. Welcome back to US Visa Info, your trusted source for the latest immigration news and changes affecting your life in America. I'm here to break down complex immigration policies into clear, actionable information you can use to protect yourself and your family. If this is your first time here, make sure you hit that subscribe button and turn on notifications because immigration rules are changing rapidly and you need to stay informed to stay protected. Today's update is absolutely critical for anyone who currently holds a green card or is in the process of obtaining permanent residency. We're seeing an unprecedented wave of new restrictions and policy changes that are creating uncertainty and anxiety for millions of lawful permanent residents across the United States. I've been receiving hundreds of calls and messages from concerned green card holders who are worried about their future, their businesses, their travel plans, and their path to citizenship. The fear is real, and honestly, some of it is justified based on what's happening right now. In this comprehensive update, I'm going to walk you through 5 major changes that are either already in effect or coming very soon. These aren't minor administrative adjustments. These are significant policy shifts that could impact your financial opportunities, your freedom of movement, your privacy, and potentially even your immigration status. So whether you're a business owner, a frequent traveler, someone planning to apply for citizenship, or you're currently in the adjustment of status process, you need to pay close attention to every detail I'm about to share. Let me start by addressing the elephant in the room. For reasons that aren't entirely clear to many immigration attorneys and advocates, the current administration seems to be implementing policies that make life increasingly difficult for green card holders. Now, some people believe this is a deliberate strategy to either encourage permanent residents to leave the United States, push them to naturalize and become citizens if they qualify, or create conditions that might cause some to lose their status altogether. Whatever the motivation, the reality on the ground is that green card holders are facing more scrutiny, more restrictions, and more anxiety than we've seen in many years. I speak with clients every single day, people just like you who are tuning in, and the number one emotion I'm hearing is fear. People are afraid to travel. They're afraid to apply for citizenship because of things that happened in their past, not crimes or serious violations, just normal life activities that they're now worried could be used against them. They're afraid to expand their businesses. They're afraid to use public benefits they're legally entitled to. This climate of fear is affecting how millions of people are living their lives, and that's why updates like this one are so important. Knowledge is power, and understanding exactly what's happening allows you to make informed decisions and take protective steps. Change number 1, the SBA loan ban for green card holders. This change was announced less than 2 weeks ago, and it sent shockwaves through the immigrant entrepreneur community. Starting March 1st, 2026, that's coming up very soon, the Small Business Administration is implementing a new requirement that will fundamentally change who can access SBA loans. Here's what you need to know. The SBA has provided crucial funding to small businesses across America for decades. These loans have been a lifeline, especially during challenging economic times. During the COVID pandemic, SBA loans and programs like the Paycheck Protection Program helped countless businesses survive. The beauty of SBA loans has always been their favorable terms, lower interest rates compared to traditional bank loans, longer repayment periods, and more flexible qualification requirements. For immigrant entrepreneurs, including green card holders, these loans have been instrumental in launching and growing businesses, creating jobs, and contributing to the American economy. But starting March 1st, all of that changes for permanent residents. The new policy requires that 100% of business ownership must be held by United States citizens. Let me repeat that because it's important. 100%. This means that if you're a green card holder and you own even a small percentage of a business, that business will no longer be eligible for SBA loans. Even if you own just 10%, even if you own 5%, your ownership stake makes the entire business ineligible. Think about what this means practically. Many green card holders have invested years, sometimes decades, working toward permanent residency. They went through the visa process, perhaps on an H-1B or L-1 visa, then applied for their green card, waited through the often lengthy processing times, and finally received that precious green card. For many, that green card represented freedom, the freedom to change employers, the freedom to start their own business, the freedom to pursue the American dream on their own terms without being tied to a sponsoring employer. Now, just when they're ready to expand their businesses, hire more employees, invest in equipment, or open new locations, they're being told they can't access the same government-backed loan programs that other business owners can use. This feels like a betrayal to many hard-working individuals who have contributed to this country for years, paid their taxes, created jobs, and played by all the rules. So, what can you do if you're a green card holder with a business? First, if you're currently planning to apply for an SBA loan, you need to act immediately. March 1st is your deadline. Get your application in before that date. Talk to your lender, gather all your documentation, and submit your application as quickly as possible. Once March 1st hits, that window closes. Second, if you're not quite ready to apply, but you're planning to, in the near future, you need to start exploring alternative financing options now. Traditional bank loans, private lenders, angel investors, crowdfunding, business lines of credit, these are all options you should be researching. Yes, the terms might not be as favorable as SBA loans, but you need to have a backup plan. Third, if you're eligible to naturalize and become a U.S. citizen, this might be the push you need to start that process. I know citizenship applications can feel daunting, especially with increased scrutiny, but citizenship gives you access to opportunities that are increasingly being restricted for green card holders. We can help you evaluate whether naturalization is the right choice for you and guide you through that process. Change number 2, increased travel restrictions and enhanced vetting. Now, let's talk about travel, because this is where we're seeing some concerning patterns emerge over the past few weeks. Before I dive into the details, let me ask you for a huge favor. If you're following US Visa info but you haven't subscribed yet, please click that subscribe button right now. I've noticed that over 45% of people who watch these updates regularly aren't subscribed yet. It's completely free, and it ensures you never miss critical updates like this one. We also do live shows every Monday at 5 p.m. Pacific Time, where we answer your questions in real time. Subscribe so you don't miss those opportunities to get your specific questions answered. Also, if you need personalized guidance for your situation, you can text me directly at area code 619-483-4549. That's my direct line for scheduling consultations, where we can discuss your specific fears, concerns, and immigration goals. If you're texting from overseas, use the WhatsApp number that's available. We have team members responding 24/7, so you'll get a quick response no matter what time zone you're in. You can also visit www.immigrationasap.com to leave your details, and someone from our team will reach out to you as soon as possible. Now back to travel restrictions. In addition to the existing travel bans and the 75-country pause that primarily affect people applying for green cards or visas, we're now seeing a troubling new trend affecting people who already have green cards. Let me be clear. If you already have a green card, you should generally be fine in terms of the travel bans themselves. The bans are primarily stopping new applications and visa issuances, not affecting people who already have permanent residency. However, here's what we're seeing, and this started approximately 3 weeks ago based on reports from our clients and viewers. Green card holders who travel to certain countries, particularly those on the 75-country pause list or the 39 fully banned countries, are being pulled aside for secondary inspection when they return to the United States. Now, in almost every case we've heard about, these inspections result in the person being released and allowed to enter the country. Nothing terrible happens to them in terms of their immigration status. But here's the problem. These secondary inspections are causing significant practical problems. People are missing connecting flights because the inspections take so long. They're experiencing delays that result in financial losses because they have to rebook flights. And when they try to get reimbursed, nobody takes responsibility for those costs. They're experiencing high levels of stress and anxiety, not knowing if this inspection might lead to something more serious. Some people have reported being questioned for hours, being asked to unlock their phones and show their social media, being asked detailed questions about their trips, their families, their finances, and their lives in the United States. If you're a green card holder planning to travel to any of these higher-risk countries, here's my advice. First, be prepared mentally for the possibility of secondary inspection. Don't assume it will happen. Most green card holders are still coming back without any issues, but don't be completely surprised if it does. Second, leave yourself significant buffer time between connecting flights. If you normally would book a 1-hour layover, make it 3 hours. If you normally would book a 2-hour layover, make it 4 or 5 hours. Yes, it makes your travel day longer, but it protects you from the financial loss of missing flights. Third, prepare a 1-page summary of key information about yourself. When you became a green card holder, why you traveled to that particular country, what family members you visited, or what business you conducted, proof that the center of your life remains in the United States. This could include things like your lease or mortgage documents, your employment letter, your children's school enrollment, anything that demonstrates you're not abandoning your U.S. residency. Fourth, have copies of important documents easily accessible. Your green card, obviously, but also your passport, your travel itinerary, proof of employment or business ownership in the U.S., and contact information for your immigration attorney if you have one. The social media vetting is also intensifying. Officers are increasingly asking green card holders to unlock their phones and show their social media accounts. Now, this is where things get legally complex. As a green card holder, you have more rights than someone on a temporary visa. You have constitutional protections. You don't legally have to unlock your phone or provide access to your social media accounts. However, the practical reality is that refusing to comply could result in even longer delays, more intense questioning, and potentially being flagged for additional scrutiny in the future. My general advice is to cooperate to the extent you're comfortable, but know your rights. If an officer is demanding access to your phone and you're uncomfortable with that, you can politely ask to speak with a supervisor or request to contact an attorney. The situation is not ideal. I'll be honest with you. Green card holders shouldn't be subjected to this level of scrutiny. They're lawful permanent residents who have earned the right to live in the United States. They should be treated with the respect and dignity they deserve, not like people who are suspicious simply because they visited family members in certain countries. I'm sharing this update partly to inform you, but also in the hope that someone in government who has the power to change these practices might see it and ask themselves, what's the point of treating lawful permanent residents this way? These aren't people trying to sneak into the country. These are people who have gone through extensive vetting, who have been granted the privilege of permanent residency, who are contributing to American society. Why create these unnecessary barriers and anxieties? Change number 3, stricter public charge enforcement. The expanded public charge rule is expected to be implemented at the end of February or the beginning of March 2026. This is a big deal for people in the process of applying for green cards, though it's less directly impactful for people who already have permanent residency. Let me explain what's changing and why it matters. The public charge rule essentially allows immigration officials to deny green cards to people who are deemed likely to become primarily dependent on the government for their financial support. The government looks at various factors, including whether someone has used certain public benefits, their income level, their education, their age, their health, and other factors to assess whether they're likely to become a public charge. The new expanded version of this rule is going to make it even more difficult for people to obtain green cards if they've used public benefits, even benefits they were legally entitled to use. There will be a more comprehensive system for checking and evaluating someone's risk of becoming a public charge. This creates a scoring mechanism that could result in people being denied green cards, even though they might have qualified under previous standards. Now, if you already have a green card, you're generally in the clear on this issue. You're legally entitled to use public benefits just like any other lawful resident. However, here's the important caveat. When and if you apply for U.S. citizenship, immigration officers may look back at your entire history as a green card holder. If they discover that you violated rules during your time as a permanent resident, even if those violations weren't discovered or addressed at the time, they could potentially use that information against you during your naturalization interview. This is why I'm seeing so many people hesitant to apply for citizenship. They're worried that some action they took years ago, perhaps using a public benefit they weren't sure they were entitled to, perhaps spending too much time outside the United States, perhaps some other technical violation, could come back to haunt them when they go for their citizenship interview. If you're currently in the process of applying for a green card and you're going through adjustment of status or consular processing, you need to be extremely mindful of public benefit usage. If you've used any public benefits, even ones you thought you were entitled to, consult with an immigration attorney before proceeding further with your application. We need to analyze whether that usage could be held against you under the new stricter public charge standards. The public charge concern is also one of the main justifications being given for the 75-country pause. The stated concern is that people from certain countries might come to the United States with the intention of using public benefits and draining resources rather than contributing economically. Whether that concern is statistically justified is debatable, but it's the rationale being used for these policies. Change number 4. Reconsideration and potential rescission of existing green cards. This is perhaps the most alarming change for people who already have green cards. According to policy manuals issued by U.S. Citizenship and Immigration Services in late 2025, the agency explicitly stated they would be going back 4 or 5 years to review green card applications for people who already received their green cards. And now we're seeing this actually happen in practice. We've had cases, including some of our own clients, where people received notices regarding potential rescission of their green cards. In one particularly troubling case, a client went for their citizenship interview, which should have been a relatively straightforward process since they'd been a green card holder for 14 years. However, during that interview, the officer began questioning them extensively about the green card they had received through marriage 14 years earlier. The officer claimed they found discrepancies in the original application. As a result, this person is now receiving a notice of intent to rescind their green card, their permanent residency that they've held for 14 years. Imagine the stress and anxiety this creates. You've been living as a lawful permanent resident for over a decade. You've built a life. Maybe you've bought a house. You have children who were born here or grew up here. You have a career. And suddenly, everything is in jeopardy because of alleged issues with an application from 14 years ago. Now, I want to be clear that these cases are not common. We're not seeing massive waves of green card rescissions. Most people who have green cards are not experiencing this. However, the fact that it's happening at all is significant, and it's important for you to be aware that this policy exists and is being enforced. If you have a green card that was obtained through marriage, especially if that marriage has since ended in divorce, you need to be particularly careful. Make sure all your documentation from that original application was accurate and complete. If there were any issues or irregularities, consider consulting with an attorney before applying for citizenship, because that citizenship interview might trigger a review of your underlying green card application. If you received your green card through employment, make sure you actually worked for that sponsoring employer for a reasonable period of time after receiving your green card. There have been cases where people received green cards through employment but left that employer very quickly, and years later, officers questioned whether the original intent to work for that employer was genuine. The bottom line is that immigration authorities now have explicit authority and apparent willingness to go back and review green card cases from years past. If they find violations or discrepancies, they can issue notices to rescind your green card. This doesn't mean you should panic, but it does mean you should be thoughtful and careful, especially if you're considering applying for citizenship. Change number 5. Priority shifts in green card processing. The final major change I want to discuss is a broader policy shift in priorities for green card processing. What we're seeing is a clear preference for what the administration considers high-value immigrants, people with significant wealth, people with advanced degrees and specialized skills, people who can make immediate economic contributions to the United States. Meanwhile, family-based immigration petitions are being deprioritized. This is most clearly visible with the controversial Gold Card program, which would essentially allow wealthy individuals to buy their way to permanent residency. Multiple lawsuits have been filed challenging this program, and I understand the frustration. People who have been waiting in family-based immigration lines for years, sometimes decades, people who have advanced degrees and valuable skills, are watching as the government creates fast-track programs for people whose primary qualification is having money. The EB-5 Investor Visa program, which requires significant capital investment, is seeing faster processing times. Highly skilled workers in certain categories are seeing movement in their cases, but family-based categories like F4 siblings of U.S. citizens, F2B unmarried adult children of green card holders, and F3 married children of U.S. citizens are facing longer and longer wait times. If you have a family-based immigration petition pending, here's what you need to do. First, stay on top of your case. File every required document on time and accurately. Any delays or mistakes on your part will only extend the already lengthy process. Second, move through the National Visa Center process as efficiently as possible once your priority date becomes current. Don't let your case sit idle because of missing documents or incomplete forms. Third, don't be afraid to hold the government accountable when they're causing unreasonable delays. Mandamus lawsuits, which are legal actions compelling the government to make a decision on a pending case, can be highly effective. Many people are afraid to sue the government, thinking it might make things worse. But in reality, mandamus lawsuits often work. They can release your case from administrative backlogs and force a decision. If your case has been pending for an unreasonable amount of time beyond normal processing periods, you have legal options. We're here to help you explore those options and determine if a mandamus lawsuit makes sense for your situation. The reality is that the government is making policy choices about who gets priority in the immigration system, and right now, family unity is not the top priority. That doesn't mean you should give up on your family-based petition. It means you need to be strategic, persistent, and willing to use every legal tool available to move your case forward. So, there you have it. 5 major changes affecting green card holders that you need to know about right now. From the SBA loan restrictions starting March 1st to increased travel scrutiny, stricter public charge enforcement, reviews of old green card applications, and shifting priorities in who gets green cards, permanent residents are facing more challenges than we've seen in years. I know this information can feel overwhelming and even scary. That's a natural reaction because these changes create real uncertainty about your future in the United States. But remember, knowledge is power. By understanding what's happening, you can take steps to protect yourself, whether that's getting your SBA loan application in before the deadline, preparing carefully for international travel, being mindful about public benefit usage, getting legal advice before applying for citizenship, or being proactive and persistent with pending family petitions. If you found this update helpful, please give it a thumbs up and share it with other green card holders who need this information. Drop your questions in the comments below. Are you worried about traveling with your green card? Are you concerned about applying for a business loan? Are you thinking about naturalization but nervous about your past? Let me know in the comments, and I'll do my best to provide guidance. If you need personalized help with your specific situation, please reach out. You can text me at 619-483-4549. You can use the WhatsApp number for 24/7 responses, or you can visit www.immigrationasap.com to leave your details, and one of our team members will contact you as soon as possible. We're here to help you navigate these challenging times and protect your American dream. Thank you so much for watching US Visa Info. Remember to subscribe if you haven't already. Turn on those notifications, and I'll see you in the next update where we'll continue keeping you informed and empowered about immigration changes that affect your life. Stay safe, stay informed, and remember, you're not alone in this journey.